Strangers to them.
Hey, we'll get Gary Palmer up
They
here.
must all stayed out of Blacksburg.
Committee on Oversight and Government Reform will come to order, and without objection, the chair is authorized to declare a recess at any time. Today's hearing is entitled Examining Employee Misconduct at the EPA. It's a topic we have addressed a few times, but it doesn't seem to be getting better, and so we will continue to highlight this as long as it takes, because in my opinion, the EPA is one of the most toxic places in the federal government to work. And if you don't get rid of the toxicity of the employees there at the EPA, we're doing a great disservice to this country. Most of them are good, hard-working, patriotic people. They care, they work hard. But you have some bad apples at the EPA, and they're not being dealt with, and they're not being addressed. And so we're going to look forward to talking about this. The Inspector General has done some good quality work, he and his team. And again, we will continue to do this until we're convinced that the EPA is actually taking care of this problem. Today, the committee is exploring numerous cases of employee misconduct at the EPA. As the Committee on Oversight and Government Reform, in addition to the broad responsibility for conducting oversight of the executive branch, we're also the Committee of Jurisdiction for federal employees. And it is our duty to explore the problems in the federal workforce. We've explored misconduct at the EPA before, and like I said, we will continue to do so until we're convinced there's actually been a change. And most notably, this committee examined the extraordinary case of John Beal. John Beal was a senior EPA employee reporting to then EPA Air Office Chief Gina McCarthy, who for years falsely claimed to be a CIA spy. Right under her nose. This went on for a long time. This person ended up going to jail, having to pay, one of the few people is actually held accountable, having to go to jail, paying hundreds of thousands of dollars in restitution. But her supervisor got a promotion. She's now the EPA administrator. And I have serious questions about her ability to actually administrate. When she had a small office, she couldn't do it. Now that she has a large one, these problems continue to persist. Unfortunately, Mr. Beal's fraud is not isolated. The head of EPA's Office of Homeland Security, this is the head of the EPA's Office of Homeland Security, had a lengthy record of sexual harassment but was not properly investigated. EPA's Region 5 was mired in allegations of sexual harassment and retaliation against those who tried to do something about it. Whistleblowers placed blame for Region 5's toxic culture squarely on former Region 5 Administrator Susan Hedman, who resigned under duress in the wake of the Flint drink water crisis. Remarking on this situation, an EPA union representative testified, quote, "There is a serious lack of accountability or transparency at EPA when a manager is the problem," end quote. These incidents represent a systemic cultural problem and failure at the EPA. Recently, the EPA Inspector General's office released details on investigations of more than 60 cases of misconduct closed in the last several months. Many of these cases contain disturbing details, and I recognize this is C-SPAN and it's an early hour, but parents, be forewarned, this is not a subject for young kids at any hour, but nevertheless, we need to expose it in order to solve it. In one case, a convicted child molester, was on EPA's payroll for years, even after the EPA learned of this offense. What's so terrible about this situation and just cannot explain or justify is the EPA knows that this person is a convicted child molester, and yet the EPA put him in a position to interact with the public. He was out there literally interacting with the public. This person was found to have police sirens placed on their personal vehicle, on their personal car, lights and sirens, handcuffs, counterfeit badge. It wasn't until a probation violation that it actually got highlighted and dealt with. In another case, an EPA employee was found to have stolen and pawned thousands of dollars of office equipment, yet was not fired. She admitted taking 7 times equipment in the office and taking it to a pawn shop, putting it in her pocket, and she's not fired. Mr. Myberg actually oversaw this person. Not directly, but was in his team. And it's just unbelievable this person was not fired. After her felony theft conviction, She is still employed at the EPA to this day. We got a lot of good, hardworking people who want and need jobs, who will serve this country honorably. Why in the world should somebody convicted of stealing from work, a felony conviction, still enjoy the employment and being paid by the United States taxpayers? We have pages and pages of similar cases, and one has to wonder if the EPA's culture and lack of accountability is a contributing factor to tragedies like the Gold King mine spill or the Flint drinking water crisis. The status quo cannot continue, and the committee will continue to investigate the EPA until cultural changes and managers' employees are held accountable for their failures. People are going to make mistakes. We understand that. These are not mistakes. These are patterns of misbehavior that are unacceptable. I introduced a piece of legislation, H.R. 4360, which actually passed this committee and passed the House, the Official Personnel File Enhancement Act, which requires a federal agency to record any adverse findings from resolved investigations into a separated employee's official personnel file. I hope this helps so that these employees cannot just toggle from one agency to the other without having their information shared with others. The bill prevents an employee facing disciplinary action from simply jumping ship to another agency that would not be aware of their negative disciplinary record. We have another case here where there were devices and air cards that were used excessively. In one case, a person in one trip, I don't know how you do this, but in one trip spent $18,000 on one air card traveling, and no restitution, no paying back the government. We have the devices, we have this $4,500 in personal international calls while on leave. And what was the punishment for that? $4,500. Taxpayers got to pay that. What was the punishment? Counseling. Counseling was the punishment. So we got a lot to talk about. The Inspector General has done a good job on this, and I look forward to a good, fruitful hearing. And with that, we'll now recognize the ranking member, Mr. Cummings.
Thank you very much, Mr. Chairman. Mr. Chairman, I do thank you for holding today's hearing examining employee misconduct at the Environmental Protection Agency. This is the third hearing our committee has held on this topic this Congress, and I am encouraged that the EPA's response to allegations of employee misconduct has vastly improved. I, like you, want to be effective and efficient. I do not want to constantly hold hearings and hear about these problems, and at some point we should be able to get them resolved. Serious employee misconduct is indeed rare. But as this committee has seen, too often agency and the Inspector General responses to misconduct cases have taken far too long. At the committee's hearing in April 2015, a little over a year ago, I asked the EPA and the IG to work together to improve their coordination in employee misconduct matters. And I did that again so that we could be effective and efficient to get things done, as opposed to going around in a circle. I also directed my staff to work directly with EPA and the IG to help develop new protocols to improve their disciplinary processes. As a result, the EPA and the IG are coordinating their efforts as they never did before. But as I often say, we can always do better. They're holding bi-weekly meetings to share information about investigations. We can do even better. They are communicating more frequently about administrative actions. They're sharing reports of investigation with agency managers and senior officials at EPA headquarters, but we can always do better. And EPA and the IG have developed expedited procedures for certain cases. The outcomes from improved coordination are indeed promising. Both the EPA and the IG have stated that the new procedures have decreased the time it takes for action on reports of employee misconduct. In his testimony, Mr. Myberg from the EPA credits the new information sharing process with contributing to EPA's taking action more quickly after the IG completes an investigation. Similarly, Mr. Sullivan from the IG's office agrees, and I want to thank you, Mr. Sullivan, for doing such a great job. And he concluded that is, Mr. Sullivan said, and I quote, "Misconduct cases are now being addressed faster and more consistently by the EPA management," end of quote. But ladies and gentlemen, we can always do better. As I said, serious misconduct is rare, but we have to take it seriously. EPA reports that it has only 14 open employee misconduct reports of investigation from the IG. For an EPA workforce of some 15,000, that's less than 1/10 of 1%. But we can do better. This committee also has expressed concern about excessive use of administrative leave. That has been a major concern of the committee. In February, the agency issued a new policy on administrative leave. Under the new policy, an EPA employee may not be placed on administrative leave for more than 10 days without approval from the Assistant Administrator of the Office of Administration and Resources Management. This policy introduces a check that addresses our concern about overuse of administrative leave and the need for stronger oversight of this type of leave. Chairman Chaffetz indicated that the hearing today will focus on approximately 20 old cases that have been closed by the IG some years ago. As Mr. Sullivan states in his testimony, and I quote, "It is important to note that most of the misconduct occurred at least 2 years ago," end of quote. In some of these cases, the misconduct is, in fact, egregious, and such behavior requires a swift and appropriate agency response. But none of these cases is currently pending. They're all closed. Now, I want to be clear. I don't see anything wrong with looking back, because I think sometimes you have to look back so that you can look effectively and efficiently move forward. We can learn from things that have happened, and so I don't have a problem with that. According to the EPA and the IG, all of these cases preceded the improved coordination process between the EPA and the IG, and I hope that you, Mr. Sullivan, will address the difference you're seeing and the impact, and of course, I'm sure you have your recommendations. Mr. Sullivan states that the new coordination process between EPA and the IG should serve as, and I quote, a best practices model for the Federal Government," end of quote. So I'm extremely pleased to hear that. It shows what we can do if we work hard with the agencies and investigators to improve their procedures. This type of work does not always get the big headlines, but it makes a real difference. It also shows that this committee we can do through nuts and bolts oversight. While I am encouraged by the progress that has been made, I believe that there are still challenges that we must and can and shall address. For instance, long investigation times in some cases may suggest a need for more resources for the IG. I just don't know. You will have to address that, Mr. Sullivan. And there are certainly other cases that raise questions about when employees are required to report criminal convictions. Mr. Chairman, as we proceed, I hope that we can address these challenges together in a truly bipartisan way like we have done over the past year, with input from the agency and the IG and the other stakeholders. Because it's a fact that if we concentrate and try to get the IG and the agencies to work more closely together, I think we can get the kind of results that we are after. And again, we can be more effective and efficient. With that, Mr. Chairman, I yield back.
I thank the gentleman. We'll hold the record open for 5 legislative days for any member who would like to submit a written statement. We'll now recognize our witnesses. Pleased to welcome Mr. Stanley Myberg, who's the Acting Deputy Administrator for the United States Environmental Protection Agency. We also have Mr. Patrick Sullivan, Assistant Inspector General for Investigations at the Office of the Inspector General at the United States Environmental Protection Agency. He is accompanied by Mr. Alan Williams. He's the Deputy Assistant Inspector General for Investigation, whose expertise may be needed for specificity on certain topics during questioning. We want to thank you all for being here. We're going to go ahead and swear in Mr. Williams as well. Pursuant to committee rules, all witnesses are to be sworn before they testify. So we'll also swear in Mr. Williams. If you three of you would please rise and raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you. Let the record reflect that all witnesses answered in the affirmative. You have testified here before. I think you know the drill. We try to keep your verbal comments to 5 minutes, but we give you great latitude today. And then after that, we'll go to questions. So, Mr. Myberg, you're now recognized for 5 minutes.
Chairman Chaffetz, Ranking Member Cummings, and members of the committee, thank you for the opportunity to testify today before you about the Environmental Protection Agency's efforts to address employee misconduct. I'm Stan Myberg, and I've had the privilege of working at EPA for nearly 40 years, holding positions at our headquarters in Washington, D.C., our regional offices in Atlanta and Dallas, as well as Research Triangle Park in North Carolina. For 18 years, I served as Region 4's Deputy Regional Administrator before retiring in early 2014. Since returning to the agency in October 2014, I've been honored to serve as Acting Deputy Administrator, discharging the duties of Chief Operating Officer for the agency. Each day, I am reminded of the excellent work EPA employees do on behalf of the American people, from our engineers and scientists in the field to our technical experts and our lawyers here in headquarters. I'm proud to be a part of the agency and its mission to protect human health and the environment. In all workplaces, there are employees who engage in misconduct, and unfortunately, EPA is no exception. When such unfortunate instances occur, we are committed to holding our employees accountable. We have and will continue to work with the powers granted to us by Congress and the administrative tools at our disposal to ensure improper conduct is met with appropriate penalties, and that conversely, excellence is recognized accordingly. But I must stress that the isolated misconduct of a few does not reflect and must not overshadow the dedication and hard work of over 15,000 EPA employees who commit themselves every day to the important work of the agency. Since my appearance before the committee last spring, we've made multiple positive changes to the EPA's management policies and procedures. EPA has taken measures to support our first-line supervisors who carry substantial responsibility in ensuring that misconduct is addressed promptly and appropriately. We have updated the first-line supervisors' toolkit and organized focus groups to ensure that we understand their needs in an overall effort to ensure that supervisors are able to take fair, legal, and effective disciplinary action for the betterment of the agency as a whole. In addition, earlier this year, as was noted in the ranking member's comments, the agency revised its policy on administrative leave, addressing a concern that this committee has raised in the past. The agency now demands additional justification and review for administrative leave requests and limits the time period of leave to 10 days, with limited exceptions, such as when an employee poses a danger to the agency and its employees. Finally, earlier this year, EPA Administrator Gina McCarthy issued an agency-wide elevation memo encouraging staff to raise issues of concern to managers and instructing managers to be receptive to these concerns. It is our hope that this directive, in conjunction with providing training and tools to our employees, will help our first-line supervisors to address misconduct quickly and effectively when issues arise. In addition to our own work, the EPA's Office of Inspector General plays a critical role in addressing misconduct and helping the agency operate at our best. As a result of the work of this committee, and especially Ranking Member Cummings, we have improved our working relationship with the Office of Inspector General, which has enabled us to take more efficient administrative action. We now meet biweekly to discuss the status of pending OIG investigations into employee misconduct, and have agreed upon procedures and timelines for effective information sharing. These meetings and the improved bilateral communication contribute to the EPA taking action more quickly upon OIG's completion of its investigations and help reduce the need for additional fact-finding by the agency in preparing administrative actions. In closing, EPA and its employees have spent nearly 5 decades working to safeguard public health and the environment for the people of this country. I am proud of what we accomplish every day. On the rare occasions when misconduct occurs, we must address it appropriately. I look forward to discussing the progress that EPA has made in this regard with you today. Thank you for the opportunity, and I look forward to answering any questions you may have.
Thank you. Appreciate that. Well, Mr. Sullivan, you're now recognized.
Good morning, Chairman Chaffetz, Ranking Member Cummings, and members of the committee. I'm Patrick Sullivan, Assistant Inspector General for Investigations for both the EPA and the CSB. I'm happy to report that since I last testified before this committee in April of 2015, the agency's internal adjudication process has dramatically improved. At the suggestion of both Chairman Chaffetz and Ranking Member Cummings, the OIG and the agency now meet biweekly about pending misconduct cases and their adjudication. These cases are now being addressed faster and more consistently by EPA management. I believe that this process can serve as a best practices model for the federal government. Many allegations lodged against EPA employees are investigated by the OIG, and some are ultimately determined to be unsupported. OIG investigations often clear an individual. Our job is to collect and present the facts in a fair and unbiased manner. We are just as proud of our work in the cases that clear an employee as we are when our work leads to a criminal conviction. Now I'd like to briefly discuss a few significant cases. In 2014, the OIG Seattle Field Office Special Agents interviewed an EPA contractor who had previously worked for EPA for the past 20 years. Stating he was addicted to pornography, he admitted to viewing pornography on his government-issued computer for the last 18 years. In the past year, he watched pornography at least 1 to 2 hours per day. He avoided detection for many years because he used commercial software to scrub his computer. He also accessed pornographic sites using search engines hosted in a foreign nation. The contractor was fired by his company. The OIG was successful in recovering $22,000 in repayments for the amount of time that the contractor had viewed pornography, and the OIG made EPA aware of the network vulnerabilities that had enabled the contractor to avoid detection for 18 years. In 2013, the OIG was notified by the U.S. Attorney's Office in Connecticut that a special agent assigned to the EPA's Criminal Investigation Division in New Haven may have been engaged in a Ponzi scheme. The special agent's name had surfaced during the prosecution of the ringleaders of a 4-level pyramid scheme involving gifting tables. New participants in this scheme would pay a $5,000 gift to the person occupying the top level. The OIG investigation determined that the EPA CID special agent had made a false statement on a required financial disclosure form wherein she concealed the fact that she had received $2,500 in cash from her participation in the scheme. In 2015, the special agent retired from the EPA. She subsequently pleaded guilty to 1 felony count of making false statements, and she was sentenced to 1 year of probation in order to pay $8,000 in fines and restitution. In 2013, an OIG special agent in the Atlanta field office proactively checked the list of EPA property reportedly lost or stolen through a law enforcement database. This search resulted in a hit on an EPA digital camera pawned in Decatur, Georgia. The subsequent OIG investigation revealed that on several occasions, an EPA employee pawned EPA cameras and camcorders at the pawn shop, resulting in a loss to the government of $3,117. The U.S. Attorney declined federal prosecution. However, we were successful in presenting the case to a local prosecutor, and the employee pleaded guilty and was sentenced to 3 years probation in order to pay restitution. This was a felony conviction. The employee's supervisor proposed the suspension of the employee for 120 days. Following an appeal by the employee, the Region 4 Deputy Administrator downgraded the suspension to 30 days. In 2006, the OIG Dallas Field Office was informed that a civilian employee was cited by the Dallas Police for improper use of emergency lights on his personal vehicle while also being a registered sex offender. He had previously been convicted in 1997 for indecent acts with a minor. The EPA employee also possessed an imitation badge which accompanied his EPA administrative credentials, which were displayed by the employee to the police officer. In 2006, the U.S. Attorney declined to prosecute the EPA employee for false personation of a federal officer and for possession of the imitation badges. EPA then imposed discipline in the form of a 60-day suspension. In 2013, the Dallas Police Sex Offender Unit requested assistance from the OIG in arresting the same EPA employee for violation of probation. He was arrested on the probation violation charge. The OIG also developed information that the employee may have viewed and possessed child pornography on his EPA computer. However, an examination of his computer revealed no evidence of this. The employee was terminated from his employment with the EPA. Subsequently, the Merit Systems Protection Board overturned the employee's termination and ordered that he be rehired by the EPA. In 2015, the employee entered into a settlement agreement in which he agreed to resign from the EPA in exchange for certain considerations. In closing, I'd like to say that we in the OIG pledge that we will continue to work closely with the agency, the Department of Justice, and Congress to ensure that allegations of misconduct are quickly and properly addressed. We appreciate your continued interest in the work of the OIG. Mr. Chairman, that concludes my prepared statements. I'll be happy to answer any questions. Thank you very much, sir.
Thank you. I now recognize myself for 5 minutes. Let's go back to that most recent case with the child molester. You said, yeah, conclude that part about the Merit Systems Protection Board. I mean, based on the brief evidence that you shared with us, the scenario of the case, what were the other considerations that he got in order to resign from the EPA?
He received a cash settlement of $55,000, I believe. I'll have to check my notes.
We paid, the American people paid him $55,000 to walk away?
Yes. But you know, the IG is not part of those negotiations.
I'm not blaming you. You're the ones that actually highlighted this. Mr. Myberg, I mean, it's hard to hold you personally responsible for that, but I mean, we had to pay $55,000 to this person?
Mr. Chairman, in this particular case, which I'm generally aware of, the case, as Mr. Sullivan noted, was one where we had proposed removal and, in fact, took removal action and were reversed by the Merit System Protection Board.
How do you lose that case?
It's a complicated case, and I'm not going to try to go into all the details, but the Merit System Protection Board found that the basis for the removal was not sustained, and so they reversed it.
So I mean, it's just pretty stunning, isn't it? I mean, what needs to change? You both are close to this situation. What needs to change? How do we need to change the Merit Systems Protection Board? Because what's not happening is we're not protecting the American people and the taxpayers, and we're not protecting the employees that have to sit by this freak of a pervert. We're not protecting them. So how do we protect the employees of the EPA and the American taxpayers? What do we need to do with the Merit Systems Protection Board to get them to make the changes?
Congressman, I would simply note a couple of things. One is that we share your desire to protect our own employees from any adverse actions by other employees. So that's a clear area with this agreement.
And how is it that this person can operate in this atmosphere for so long? I mean, in the case of Dallas, how is it, Mr. Sullivan, you've looked at this case closely, how is it that this goes undetected for so long? It wasn't in our system, or?
Well, it didn't go undetected. It was not reported to the IG. In 1999, our investigation revealed that the management in Region 6 in Dallas, EPA management, found out about his conviction. And at that time, he was stopped again by the police for using lights and sirens. I don't know about the sirens, but I know about the emergency lights. And that was brought to the attention of EPA management. He was counseled and told not to do that again, but it was never brought to the attention of the IG in 1999.
And what was his position back in 1999? What was he doing?
He was an enforcement officer doing civil inspections for the EPA.
So his job would be to do what?
To go out to a site and look, to examine and determine if there was any environmental violations.
So we're putting it out there, interacting with the public. Mr. Myberg, how does this happen? I mean, if you know that this person has to register as a sex offender, has this type, why do you put them in a position to have to interact with the public?
Mr. Chairman, I don't believe there's any particular rule that says that if an employee is convicted of a crime in general, that they have to then report that to the agency.
Should that be the case? Should they have to report ongoing?
Mr. Chairman, I think that's an important issue, and we're happy to work with you and with the Office of Personnel.
I'm just asking your personal opinion. Do you believe that if you're convicted of a felony?
Mr. Chairman, again, I am here in my official capacity. I would rather stay with my official answer.
As somebody who's convicted as a sex offender, is there an internal policy to prohibit those types of perverts from interacting with the public in person?
Mr. Chairman, we've asked that question, and we do not believe that we have the authority to institute a policy to that effect, and we are not different from other agencies in that regard. But it's an important issue, and we agree with you on that.
All right, somebody here on this panel better sponsor a bill to get rid of perverts interacting with the public, because this is not acceptable. I can't imagine, somebody comes with the authority of the EPA badge, and then they've got sirens or lights on their car, and they're a registered sex offender? I mean, can you see the disconnect, why people would be outraged if they showed up at your place of business or work, or some mom with their young child, and suddenly you encounter this person? And how do you stand for that?
Mr. Chairman, again, certified badge law enforcement officials have special responsibilities, even more so than ordinary EPA employees.
I can't believe you lost that case, but part of me thinks we're going to have to work here to, let's get the Merit Systems Protection Board up here and start explaining to themselves how in the world they think this is in the best interests of the United States of America. My time's expired. We'll now recognize Ms. Watson-Coleman for 5 minutes.
Thank you, Mr. Chairman. Good morning, gentlemen. Thank you for being here. A lot of these cases, all the cases that we're discussing, were either resolved in 2014 or 15. So these are kind of old cases, right? And so since then, we've had changes in our policies and practices at the EPA that would at least address allegations of misconduct that come before them in terms of resolving them, and as well as administrative leave policies. Is that not correct?
Yes, Congresswoman, that's correct. We feel like in the last year we've made considerable progress moving forward. I would agree with the ranking member that we can always do better, but we feel like we made considerable progress in having better communication with the Office of the Inspector General and clearer policies on the use of administrative leave.
Could you explain sort of briefly what specifically has changed that you've informed the rank and file and the supervisors, and what's the process for holding them accountable, aside from just interacting with the OIG?
The interaction with it's in so many ways all of a piece. We've discussed with all of our employees the importance of first-line supervisors and their responsibilities in conduct and discipline cases. We've also, again, as I mentioned, on the administrative leave, made sure that this cannot be used, and the use of administrative leave has been curtailed for more than 10 days, which was a concern of this committee. But the interaction involving the Inspector General has been tremendously important, because we refer cases to the Inspector General when we have evidence of misconduct and ask the Inspector General to investigate them. And it's very helpful in the course of that investigation to have the interaction we now do, so that we can be clear that when we get information as quickly as possible, we can move on it.
So thank you. Thank you. Mr. Sullivan, are you feeling that this interaction is helping to create a better environment, a more protective environment, and a more accountable environment in the EPA?
Yes.
Once you do an investigation, once something has been referred to you, you do an investigation. In addition to your findings, do you make any recommendations back to the EPA about the employee that has been investigated?
As a head of investigations for the EPA, we do not make recommendations in our investigative reports. However, our auditors and our evaluators make recommendations as part of their job, but that's a different part of the IG. So in a typical misconduct investigation, we would report the facts and chest the facts, and we would not make a recommendation.
So you would report the facts to the EPA plus the auditing?
Well, it depends. If we saw a systematic problem or a problem that was cross-cutting, for example, in the Beal investigation, we determined that there were, from the investigator standpoint, that there was some safeguards that weren't being followed. For example, they were batch approving Mr. Beal's T&A, his time and attendance, every week, which was a vulnerability. So we reported that to our auditors, and they did an audit. But normally in our investigations, ma'am, we just report the facts concerning the specific allegation before us.
Do you feel that we've sufficiently moved in the right direction with the EPA holding people accountable and developing the kind of information sharing system and accountability system that will mitigate these kinds of cases in the future? I'm not talking about the one about whether or not the individual who was a convicted sex offender should be hired, and if so, under what conditions, but otherwise.
Otherwise, I could tell you that in the past year, as Mr. Myberg alluded to in his testimony and mine, by meeting biweekly, we have streamlined the process, and we've broken down some barriers, and we've touched each other as human beings and managers addressing a problem. And again, though, I want to make it crystal clear what our role is in the IG, Office of Investigations. We just report the facts. We have nothing to do with the ultimate disciplinary process.
I just have one quick question, both of you can answer quickly, hopefully. Are there other things that should be happening, either on EPA, on your side as the manager of the organization, or as, from your observation, as the IG looking into the organization? And have you discussed those things? Are there things in the works now?
Yes, I'll cite one thing that we have in the works. We are trying to get additional employee labor relations support to our first-line supervisors and make sure they have good information on cases that may have come up in the past that are similar to ones they might face. Because fortunately, for most of our first-line supervisors, a conduct and discipline case is a very rare thing. And so when one comes up, we want to make sure they have a context for whatever action they may take.
Thank you. Mr. Sullivan, do you have anything to say to that in 2 seconds?
Yes, ma'am. We don't have enough agents to do the investigations. In the past 5 years, we've gone from 360 FTE authorized to 289, and I've personally lost 15 to 20 agents that can no longer work cases. So I'm always trying to play catch up.
I hope you have less cases to have to investigate. Thank you, and thank you, Mr. Chairman.
I think the gentleman from Florida, Mr. Mike, is recognized for 5 minutes. Thank you, Mr. Chairman, and it's good to hold this hearing and review some of the conduct of some of the employees of EPA. Important responsibility in that agency to carry out. I had the opportunity to chair civil service on this subcommittee on this panel some years ago. And I'm a supporter of the civil service system, and it was set up decades and decades ago to protect civil servants, public employees, from abuse, being politically abused, relieved of their positions. Isn't that pretty much the case, Mr. Myberg and Mr. Sullivan? Yeah.
Yes, Congressman, it is. And that's very important that we make sure that the system is not subject to
not rigged to take hard-working people and then to cast them out on some political basis, and I think that should be protected. However, the reports we have here, I have 12 pages of some of the most egregious abuses. I can't find any instance in which anyone was fired. Did you say there were 15,000 EPA employees? Is that correct? More than that?
I'm sorry, yes, that's correct.
Did you say, Mr. Sullivan, you have 280 investigators or
No, sir. We have
staff?
we had 360 5 years ago. Now we're down to 289.
289 staff, and what do they do?
Well, we have investigations.
So they
investigators,
investigate.
some auditors, some
And
evaluators.
within the 200, I'm sorry, but they're investigating, looking at reviewing the conduct of the 15,000 EPA employees?
I have 50 agents right now that can
50?
do
Okay, we have them.
investigations.
How many, of the, last year, 2015, how many people were fired from EPA?
I'd have to defer to Mr. Myberg. I don't know.
Mr. Byberg, how many were fired?
I don't know,
Were
Congressman.
any ever fired for for misconduct?
Yes.
Can you supply? Do you think it's more than just my fingers and my toes?
Congressman, of this, there were, and I'm going I want to be clear about my answer.
I tell you that almost nobody, well, nobody here got fired. The only one actually dismissed was the contractor. Now, what's troubling is some of the offenses, and then I just heard the deal cut to pay $55,000 in a settlement. Was that true, Mr. Sullivan? You said you weren't involved in the settlement.
That's correct. From my
Was that
recollection,
was
it
that
was
the
$55,000.
pedophile or the
Yes,
the kitty
that was the child molester.
So we're paying child molesters $55,000. Nobody gets fired. Now here's one EPA official in Washington, GS level 15. GS level 15 at DC is getting a minimum of $125,000. Here's the Okay, this guy sat around for years, for the past several years, and watched porno. They're getting $125,000. And actually, I think he's still on the job. Must be a great job where you could just sit around, collect $125,000 a year. Here's a $90,000 GS 13, at least $90,000 here at DC. A search of the employee's EPA issued computer found 507 pornographic images, as well as a pornographic story written by the employee containing description of it. But I won't go into all that for public consumption here. The employee was issued a notice of proposed removal but retired. So nobody gets fired. The way out is most people either retire. Civil service was not set up to protect these folks. It was protect folks against political manipulation. Now, this has to be demoralizing to thousands and thousands of hardworking EPA officials to see these people who either are involved in misconduct, misappropriate, they were stealing money, and I can't find a single instance in which anyone was fired. They mostly retired. And when they retire, they get a pretty good retirement, don't they? They get their regular retirement. There's no penalty to their compensation when they retire, is there?
Congressman, under current law, there is no penalty for it. People can retire or resign at any time.
And that is the MO. You steal, you sit around and watch porno, you get convictions outside, and you're either voluntarily resign and go to retirement, but nobody gets fired. I yield back.
I thank the gentleman from Florida, and I recognize the gentleman from Maryland, Mr. Cummings, for 5 minutes.
Thank you very much, Mr. Chairman. Let me try to understand, Mr. Sullivan. There are 14 open cases, is that right?
That's not 100% accurate, Mr. Cummings. We have 14 cases pending at the agency in which we've already submitted the report of investigation. We have many, many more in the pipeline that we have not yet written the report of investigation. So we have approximately 90 pending misconduct cases right now.
Okay. And the reason why I asked that is because I said to myself now, you talked about the agents that are available to investigate. And I was saying to myself, with 14 cases, I know it takes a lot of manpower, but so you've got about 90 cases that you're actually involved in.
Yes, Mr. Cummings, but we also have in excess of 150 additional cases, 97 fraud cases, contract and grant fraud, plus we have a number of threat investigations, a number of theft investigations, some assault investigations. So it runs a spectrum. But for the misconduct, we have currently 90 pending cases, 14 of which have already been presented to the agency and we're waiting adjudication. The other 76 are in various processes of us investigating.
Now, when we have a situation where somebody is hired and then commits a serious felony, do they have a duty to report? In other words, they're already hired. What's the situation there, and where do we draw the line there?
Well, Mr. Cummings, it's my understanding that for the most EPA employees, there's no requirement to report either an arrest or a conviction. Obviously, if you're a law enforcement officer like myself, you must report. If you're an attorney, you must report. If you work for the IG, you must report. Or if you have a security clearance, you must report an arrest or a conviction. But short of that short list, I don't believe there's any requirement for any EPA employee to report either an arrest or a conviction.
Now, do you have an opinion on that? I'm just wondering because I know one of the cases had a situation where somebody was convicted after they were hired and with no duty to report. It's very interesting because when I practiced law, I saw a lot of cases, not government cases, but others, where people failed to report and they were immediately fired when they found out. But so we don't. Are there other agencies where they have to? The list is longer than that 3?
Yes, Mr. Cummings. Like for myself, I've been a federal law enforcement officer my entire adult life, and I've worked for the FBI and the Secret Service and the Federal Air Marshals. And in those agencies, you absolutely have to immediately report an arrest and certainly a conviction. Whether you're carrying a gun or you're a civilian employee in those agencies, you have to report. So I was a little bit surprised when I came to EPA and I learned that the EPA, rank-and-file EPA employees did not have to do that. I've accepted that as that's the rules, but I was a little curious as to why you just, for the sake of knowing, if you put trust and confidence in a particular employee, it may affect your judgment or your decision-making if you knew the person was just convicted of, say, theft or embezzlement in a private life.
Tell me this: we were just talking about a case where somebody received counseling, some kind of counseling. When you look at the counseling situation there at EPA, do you think it's helpful? I mean, do you think it's strong enough? Do you think, and what, and maybe Mr. Myberg can answer this, what triggers counseling? In other words, how do I determine whether somebody should have counseling and that be a part of, say, keeping them on? And I know you don't have a lot to do with the final say, but I was just, Mr. Myberg?
Thank you, Ranking Member. It depends. The short answer is it depends on the case and what the nature of the offense is. If it was an offense that was created out of ignorance or simply the employee did not know what a rule was, then counseling may be appropriate. But each one of those cases has to be evaluated on its own merits based on the facts of the case and the applicable law and regulations.
All right. Now, Mr. Sullivan, my time is running out, but Ms. Coleman had asked you all about where we go from here. Tell me clearly, what would you like to see done so that we can be effective and efficient, and so that we can basically put you out of a job?
Well, Mr. Cummings,
I'm not trying to get rid of you, but you understand what I'm saying.
Thank you, sir. I appreciate that. I'm concerned that when we have an investigation, and because I don't have enough special agents to expeditiously investigate allegations, we eventually get to them, but the old saying, justice delayed is justice denied, I'm very concerned that I don't have enough agents to adequately and immediately address some of these allegations. That's why I have so many cases in the pipeline. And if you do the math, my average in my Office of Professional Responsibility, which is a special unit I have at headquarters doing essentially GS-15s and SCSers and political appointees, they average 9.5 cases each. And the agents in the field average approximately 7 cases each. And a lot of those cases in the field are multi-million-dollar fraud investigations that are very involved. So I simply do not have enough agents to expeditiously investigate every case that I have on my plate.
Now, will you continue to work with us to try to come up with solutions to the problems? I got the money piece. I agree with you. But, you and Mr. Myberg have been wonderful with regard to sitting down and trying to work out things. Will you continue to do that, sir?
Absolutely. It's beneficial to both my office and to the agency as a whole, because we can move things down the field much quicker.
All right. Thank you very much, Mr. Chairman.
I think the gentleman from Maryland, the gentleman from Georgia, Mr. Heiss, is recognized for 5 minutes.
Thank you, Mr. Chairman. Several of the cases of employee misconduct that has been reported from the IG took place in Region 4, where you, Mr. Myberg, were the administrator. One of the cases in particular that's on my mind took place in your watch, referring to a GS-12 employee making over $100,000 a year who was found to be stealing thousands of dollars of property from the EPA. In fact, that the individual pled guilty to felony theft and was placed on 3 years probation, but astonishingly only received 30 days suspension by the EPA. Mr. Myberg, my obvious question is, how in the world can an employee be found guilty and admit to felony criminal charges of stealing from the EPA and not be fired?
Congressman, I'll speak to that case since, as you note, I was the deciding official. This was, and I want to be clear that there's not a question about whether what the employee did was wrong. What the employee did was wrong, and she needed to be held accountable for doing something wrong. When a case comes forward we get...
It was criminal.
The criminal conviction, the settlement in the court case occurred after we took disciplinary action. There are two paths, as you probably know, whereby you go on this. One is the path of administrative discipline, and the other is a potential referral to either the U.S. attorney or to local authorities, which occurred in this case. At the time we took administrative discipline, the question before us was what was appropriate administrative discipline given the information we had from the investigation report, which we did.
So, you know, it's astonishing to me that a 30-day suspension is all that someone gets for even pleading guilty of felony theft. We've got the taxpayers on the hook for this type of behavior. And so you were the administrator, were you involved in determining the disciplinary action?
Yes, I was the deciding official in that case.
So in deciding on that case, you're saying that you were not aware of the criminal charges when you made the final decision?
I was generally aware that there was a possibility of proceeding, but I did not know what the outcome of that was.
But you were aware of thousands of dollars that had been stolen?
I was aware that approximately $3,000 in camera equipment had been pawned and then lost to the agency through that transaction.
And in your determining decision, that was only worth a 30-day suspension?
And there were many factors. In any individual case, there are many factors that the deciding official uses. They're generally referred to as the Douglas factor, but there are many factors that the deciding official uses in deciding what an appropriate penalty would be. And I'm obligated by law to consider all of those in reaching a decision on a penalty.
It's just amazing to me that the agency doesn't do more to punish people who are stealing from the agency, who even plead guilty to criminal theft, and they still have the right and privileges on the shoulders of taxpayers to continue working for the agency. I just can't wrap my mind around this. This committee has heard time and again of the EPA literally plagued with constant employee misconduct. And yet at the same time, the EPA routinely goes after businesses across this country for much less serious offenses and throws fine after fine after fine to businesses that often are doing virtually nothing in comparison. I mean, we hear stories of businesses all the time for slight infractions getting serious fines, and yet here we have the EPA in a double standard having employees involved in criminal behavior, and they just get 30-day suspensions or less. It's an absolute hypocritical double standard. And it's disgusting not only to me to hear these kind of things, but the American people are fed up with this kind of stuff. They get slapped time and time again with fines because a ladder is in the wrong place or whatever the slight infraction may be. And yet you guys are putting up with this. The state of the affairs of the EPA to me is totally unacceptable, Mr. Chairman. And I just believe that the EPA wants the trust of the American people in this committee. They've got a long ways to go to get their house in order. And I yield back. Thank you.
I thank the gentleman from Georgia. The gentleman from Georgia, Mr. Carter, is recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Sullivan, in March of 2014, an EPA employee was arrested, jailed, and indicted for marijuana possession. It's my understanding that this particular employee had a grow operation and was arrested on felony possession charges. In fact, I believe you highlighted this in your November 2015 report that on the EPA's use of taxpayer dollars for extended administrative leave for employees who had been suspended for misconduct. According to that report, this employee was placed, Mr. Meeberg, you listening? According to that report, this employee was placed on administrative leave for 7.5 months. Is that correct?
Yes, sir, Mr. Carter, that's
No,
correct.
that's not. Tell me it's not correct.
No, it's correct, sir.
It is correct.
Yes.
Okay, again, he was charged with felony possession. He had a grow operation, and he was put on administrative leave and paid for 7.5 months.
Yes, sir.
As I understand it, the EPA policy only allows for 10 days of administrative leave when employees committed a crime for which they could be imprisoned. Is that correct?
That is correct, but that's the new policy, Mr. Carter. I'll defer to Mr. Myberg. The 10-day.
I'll get Mr. Myberg.
It's a new policy.
A new policy implemented after this?
Yes.
Okay. So it wouldn't apply then?
No, the 10-day limit did not apply then.
So that's why we paid him for 7.5 months?
Well, I can't explain why. We were not, again, we're not.
I'm
involved in
sure
this
I can't,
process.
I can't, and even if you could, I couldn't understand why. Do you know that, why, Mr. Myberg, why would the EPA do this? Explain to me that. Why would you do this?
Congressman, I can't speak to the particulars on this case and what judgments were made by the individual deciders.
Well, who can? We need them here.
That would have had to be the regional office and to decide where this event occurred. I will say
So
that
who makes these decisions? You know who we need here? We need somebody who we can fire. That's who we need here. Who makes this decision? Who made that decision?
decisions on conduct and discipline are taken by proposing officials, who usually are the employee's supervisor or their division director in a region, and then final decisions made usually by a deputy regional administrator, who is a career appointee.
And who do they answer to?
They answer to a regional administrator.
Yeah, you had, I think you said the magic words, career appointee.
Yeah.
I think that was probably the answer to the question, career appointee. Yeah, let me ask you, Mr. Myberg, I've been sitting here listening, and it seems that, with all due respect, sir, it seems that you're just matter of fact, yeah, that's right, and that's the way it's supposed to be. In the report, in the November 2015 report, Mr. Sullivan, did you not indicate that EPA needed to change some of their policies and protocols?
Yes, that was, to be correct, that was an audit report, but yes, the recommendations were made.
Mr. Myberg, have you done that?
Yes, indeed, we have, and the example,
Are they ready?
they're being implemented on.
They're being
administrative leave.
implemented. When will they be implemented?
No, they're being implemented now.
Now? So they're in place now?
Yes. The policies, to be specific, the policy on administrative leave, to limit administrative leave in any case to 10 days unless there is approval by the assistant administrator for the Office of Administration and Resources Management under very, very
Okay, I'm okay with that, because this is the only time something like this happened. It only happened once, and then we corrected it. Is that right, Mr. Sullivan?
Well, no, there was massive abuse with administrative leave prior to the changing of the rules. And our report, our audit report pointed that out.
Mr. Myberg, have you ever worked in the private sector?
Not for many years. I thought I was going to have that opportunity following May 2014, but it didn't work out that way.
Well, I suspect there's a story there. Seriously, do you think they would tolerate this in the private sector?
The private sector, I can't speak to a comparability in the private sector. I know in the private
I
sector.
can, because I'm in the private sector. Or I was. I guess I'm not now. But I was. But you know, I mean, this is, my colleague just made the point. You go and you find people. Well, we got the answer today as to why they're being fined. Because we got to pay people on administrative leave who've been charged with felonies. That's why you're getting that fine for that ladder being in the wrong place. I got the answers I needed today. Thank you both. That's exactly what I needed to know. Mr. Chairman, I yield.
I thank the gentleman from Georgia. I recognize Ms. Lawrence from Michigan for her 5 minutes.
Thank you. We've heard discussion today about the new process for information sharing at EPA and the dramatic improvement in management's response to misconduct. I want to applaud the agency and the IG for your work to streamline the disciplinary process. Our hearing on the federal workforce often focus on, especially in this committee, on the negatives. So it's good to hear about the positive changes that are occurring. Many of the failures that we've been hearing about were prior to the changes, so I do applaud you. I want to focus on another policy change that took place in EPA regarding administrative leave. I also want to note that this is the 6th hearing that this committee has held over the past 2 Congresses on the management of employee misconduct issues at EPA. Mr. Meeberg, am I saying that right? Myberg. I'm pleased to hear that the new policy increases oversight over the placement of employees on administrative leave during misconduct, investigation, and adjudications. The new EPA policy also requires managers to document alternatives to administrative leaves that were considered and why they were deemed not feasible. Is that correct?
Yes, that's correct, Congresswoman.
So, would you tell me today and enlighten us, what alternatives should managers consider before placing an employee on administrative leave?
Managers should consider alternatives about what other kind of work the individual could be doing instead of their regular duties if it turns out that the investigation will impede their ability to conduct their regular duties. So that would be the first place that you would look, to find work that they can do while the proceeding is occurring.
Do you expect this new policy to reduce the amount of time that employees are placed on administrative leave? Is that the goal?
Yes, indeed it is. We've been very sensitive to the comments from the members of this committee about concern about the abuse of administrative leave, and we want to curtail that practice.
Okay, so now policy has been in place since February, am I correct?
That's correct.
So have you seen any difference? Has there been a reduction?
We've seen a pretty dramatic difference, and since the policy has been put in place, we've only had 2 requests that have come forward, and the fact that requests are not coming forward by itself is a good sign that the policy is going into place. And of the 2 requests that came forward, one was approved because of a risk to the safety of EPA employees, and the other was denied.
I often like to interject into these conversations that I served in a federal agency and was in HR, labor relations, and really had the responsibility of looking at how do you deal with separating inappropriate behavior but respecting the rights of an employee. It's a delicate mix. You have to hold employees accountable, and I can tell you, sitting here today, I want employees held accountable. It is our expectation of our public. But every employee is a citizen of these United States. They have rights, and the agencies should have, and I'm glad to hear that you've reviewed these processes to make sure that they're consistent, that they're not up to a flim of a manager, and that we hold people accountable. But basically, we're there to do the work that my tax dollars and every other Americans expect to happen in this agency. So I will continue. I hope we don't have to have 6 more hearings on this, but I will continue to stay focused and looking at what we're doing. And Mr. Meeberg, I expect for you to continue to monitor this and be proactive and make sure that EPA, with all the budget cuts that we're doing here, that EPA is doing the work that we need them to do to protect our environment. Thank you so much.
Thank you.
I thank the gentlelady from Michigan. I recognize the gentleman from Alabama, Mr. Palmer.
Thank you, Mr. Chairman. Mr. Myberg, I think we've pretty well covered some of the problems at the EPA regarding sexual misconduct, but there are other forms of employee misconduct that I want to address, specifically about an investigation that's going on in the Birmingham, Alabama area involving the EPA, in which EPA employees, I think, have acted improperly in conducting the investigation, specifically seeking access to property without getting the permission of the owner, and actually intimidating people who are occupying houses on the property. I have an affidavit here in which one of these people who reside on the property made these allegations that officials of the U.S. Environmental Protection Agency, the EPA, approached me to seek permission to test the property. The EPA officials presented me with a document to sign to allow them to sample the yard. The EPA representative was acting very intimidating and informed me that I needed to sign the release over even though I did not own the property, which is a clear violation. I felt very intimidated and compelled to sign the release even though I did not want to do so. Upon signing the release, I asked the EPA official what was so urgent in trying to obtain access to my yard. The EPA officials responded that they are in Tarrant, Alabama, which is right there, suburb of Birmingham, to shut down the ABC Coke plant. Does the EPA discipline employees who act in such an overzealous manner?
Congressman, anytime we have an allegation of misconduct, we investigate it, and if the investigation shows that misconduct has occurred, then we will take action to hold the employee accountable.
So do you punish that, or do you encourage it?
Again, Congressman, when an allegation occurs of misconduct, we investigate it, and as Agent Sullivan or Director Sullivan specified, one of the things that occurs on many investigations is the investigation does not find any wrongdoing. When it does, we take appropriate follow-up action to hold the employee accountable.
Well, I would like to point out that this is not the only affidavit like this. There are several others, and you know, we're not going to release them. I'm not going to enter them to the record or use their names this time. But do you believe it is appropriate for the EPA personnel to pressure and intimidate citizens into endorsing EPA's agenda?
Congressman, I'm not familiar with the specifics that you're referring to.
I'm just,
we'll be happy
well,
to take that back.
The specifics here are the EPA employee forced this renter to give access to property they didn't have legal access to in an intimidating manner, and then afterwards told them that the whole point of the investigation was to shut down a legal business. Is that how the EPA does business? Do you encourage your employees to do that? Do you allow them to intimidate? Do you allow them to operate outside the law? Are you aware that this goes on?
Congressman, again, I'm not familiar with the specifics of the cases you're
I'm asking you in general.
In general, we ask employees to behave in accordance with good, solid standards of professional conduct.
Well, they don't always. Do you believe it's appropriate for EPA employees to seek to shut down a legitimate business that employs many people?
Again, Congressman, our job is to go out and to enforce the law, to make sure that people are protected and the laws are followed. That is what we do.
Let me tell you, I've got a number of issues with EPA, how they do business, how they handle their investigations. Senator Richard Shelby, Senator Jeff Sessions, and I sent a letter to Administrator McCarthy and Regional Administrator for Region 4, Heather McTeer-Toney, back on February 26th of this year, asking for information about the EPA's investigation of this area, and got a letter back saying that with respect to your concerns about the EPA's enforcement approach and/or theories of liability against any PRP associated with the site, unfortunately, EPA cannot engage in any level of discussions with third parties, including members of Congress, as articulated in the memorandum, and I've got the memorandum here. That seems to me to undermine our oversight ability, and I intend, Mr. Chairman, to look into this further. I would like to enter my letter and the EPA's response into the record if there are no objections.
Without objection, so ordered.
I yield the balance of my time. Thank you, Mr. Chairman.
I thank the gentleman from Alabama. The gentlewoman from Illinois, Ms. Kelly, is recognized for 5 minutes.
Thank you, Mr. Chair. Mr. Meinberg and Mr. Sullivan, thank you for being here. Misconduct from a few bad apples gives all of the other hardworking federal employees a bad name. As elected officials, we can relate to that too. Our goal is to ensure that agencies act swiftly and fairly in cases like these. This committee has worked with agencies to improve and streamline their internal procedures while preserving employee rights. Today, we've heard about the new policies and information sharing processes at EPA and the IG. Mr. Sullivan, in your testimony, you state that since the committee's hearing on EPA misconduct in April 2015, the agency's internal adjudication process has, and I quote, dramatically improved. Is that correct?
Yes, Ms. Kelly, that's correct.
Thank you. Mr. Myberg, these improvements at EPA have occurred through changes in administrative policy and process, not through legislative change. Is that correct?
Yes, Congresswoman, that's correct.
Mr. Myberg, in your opinion, do managers at your agency have sufficient tools under current law to deal with allegations of misconduct like the ones we've heard about today?
Congresswoman, I do in fact believe that. It is always the case, as Ranking Member Cummings said in his opening statement, that we can always do better, and we strive to do that. But we believe we have the tools we need in the agency to execute effective conduct and discipline.
Okay. It's important to remember that due process protections in our federal civil service laws are there for a reason. In May 2015, the Merit System Protection Board issued a report that stated, and I quote, "More than a century ago, the government operated under a spoils system in which employees could be removed for any reason, including membership in a different political party than the president or publicly disclosing agency wrongdoing. The result of such a system was appointment and retention decisions based on political favoritism. Constitutional due process protections arose from the law that Congress enacted to fix that broken system. Mr. Myberg, is removing due process from civil service laws necessary to address serious misconduct?"
Congresswoman, we believe that we can address serious misconduct through the application of our processes that do in fact protect due process.
Mr. Sullivan, do you agree that without a legislative change, it is possible that improvements can be made within agencies that streamline the disciplinary process?
Yes, Ms. Kelly, I agree with that.
Are the changes at EPA an example of such an improvement?
Yes, I could tell you from my personal experience, the biweekly meetings have dramatically improved the process.
Okay. Thank you. It seems to me that agencies currently have the tools to deal with allegations of misconduct, but they sometimes do not use them as efficiently and effectively as they could. I think that is exactly when this committee, through its oversight function, can help agencies improve their procedures. Thank you, and I yield back the balance of my time.
I thank the gentlewoman from Illinois. I'll recognize myself for 5 minutes. Mr. Sullivan, thank you for the testimony and for the dedicated work of your Office of Inspector General within the EPA. I would like to thank you especially for the work of the OIG in cooperation with this committee to shed light on the misconduct at the EPA and efforts to bring about accountability and reform within that agency. We recognize your progress while still acknowledging there are still many ongoing challenges within the agency's personnel and management. We know that long-term reform and improvements to personnel management requires more than just new procedures and updates to manuals. It requires active support from leadership top to bottom to foster a culture of integrity, accountability, and best practices. Would you agree, Mr. Sullivan?
Yes, sir, I do.
Now, Mr. Myberg, you're currently serving in one of the top leadership posts at the EPA, right?
Yes, sir, that's right.
And it seems from our discussion today you're pretty astute about the law, right?
I am not a lawyer and would not make that claim.
No, but you've been very articulate about the banter from both sides in regards to this claim or that claim. You're pretty articulate about that, right?
Thank you. That's not for me to judge.
Well, I mean, Mr. Heiss actually engaged on you because you were the administrator that actually made the decision on that case. So you're pretty familiar with, personnel management, right?
Yes, over the course of my career, I had a number of conduct and discipline cases come before me as the deciding official.
Now, could you please briefly describe and summarize your job description today?
My job description is I am the agency's chief operating officer, and I perform such duties as are assigned to me by the administrator.
Now, let's go through that. You're serving as the active EPA deputy administrator, and you should understand the law, right?
I'm, again, serving in...
No, but you should understand the law. I mean, you're predicating this based on understanding the law, and all those underneath you should be following you. So you have also been nominated by the President to serve as the EPA Deputy Administrator. Under the Federal Vacancies Reform Act and recent case law, do you realize you cannot serve in an acting capacity for an office that you've been nominated for?
Congressman, I am aware of the legal case that you're referring to and have been assured by counsel that my service is lawful.
Whoa. Moreover, do you realize that in such a situation, your actions have no force or effect under the law? And what I'm actually talking to you about is you're the CEO. You're applying these laws. So they basically go away. I'd like to have the name of the council that gave you that information because it's in total violation of federal statute and law. Will you provide that to the committee for?
Yes, we'll be happy to do that.
Have you ever discussed with anyone at the EPA that the fact that under the Federal Vacancies Reform Act, you cannot serve as the acting deputy director after you've been nominated to serve in the same office? Are you concerned that your actions can and will be challenged given that they have no force or effect under the law?
Congressman, I have been in consultation with our council and been assured that the
I'd like
actions
to have
I've
all
taken-
names of individuals that gave you that because that's contradictory to federal law. Do you believe that you should step down as the acting EPA deputy administrator given that the law says that your actions have no force or effect?
Again, Congressman, I've been consulted with counsel and that all of my actions.
I want all individuals that gave you that consultation's name and titles. Your actions in the defiance of the law by your agency and this administration baffles me. Moreover, it does not surprise me. The EPA under this president has a long history of blatant disregard for the law and disrespect for the oversight authority of Congress. Your boss, EPA Administrator Gina McCarthy, committed perjury and made several false statements at multiple congressional hearings trying to defend the fact-defying waters of the United States regulations. On numerous occasions, Administrator McCarthy not only broke the law by lying to Congress, but in doing so, she also lied to the American people in order to force misguided and overreaching regulations that have no scientific basis down our throats. Perjury before Congress is perjury to the American people and an affront to the core principles of our republic and the rule of law. You actually sitting here impersonating the CEO, being offered as to that office by the President is affront to that as well. That is why I've introduced articles of impeachment to remove Administrator McCarthy from office. But before you get too excited, Mr. Meeberg, thinking that you may get another astronomical promotion in McCarthy's place, I think you should step down as well. You cannot serve as the acting official when you are nominated to fill that post permanently. It's against the law. It's plain and simple. The personnel management within the EPA is a mess. But that is no surprise when the agency's top officials are willful lawbreakers themselves. You create that culture, and that's why you were set up accordingly. And that's why it's going to be really nice for me, because we have figured a way to make sure that those impeachment proceedings go to the floor and make somebody atone for their actions. It's actually a mess, and it's sad that we have to bring this, particularly when you should know the rules better. And that goes along with the council. So I will expect those names of all those council and their titles immediately to this committee for review. I thank you, and I'm disgusted. I now recognize the gentlewoman from District of Columbia, Ms. Norton.
Thank you, Mr. Chairman, and thank you, Mr. Myberg and Mr. Sullivan, for being here. To get back to one of the themes of this hearing, I've been interested to hear about the testimony that's been given on improved coordination between EPA and the IG. And the reason that interests me is that we obviously want to reduce the time that employees spend on administrative leave when obviously not doing anything for the agency. So I'm interested in the investigative process. I recognize that it takes time. You can't cut corners. You can be sued. So, and I also understand that some of these investigations can be very complex. Mrs. Sullivan, I'm interested in the funding available to the agency to do the job that needs to be done in investigating. Can you tell me what the staffing levels are for the team that investigates misconduct allegations?
Yes, ma'am. I could tell you, in general, the current authorized FTE for the Inspector General's office as a whole is 289 employees. That's dropped in the last 5 years from 360. In my office, I had an authorized FTE strength of 76 5 years ago. I'm now down to 61. But because of the uncertainty in the budget, I haven't been able to hire back up to 61. I now have 55 full-time employees, and 50 of which are special agents. The rest are professional support staff or scientists or computer forensic people. I have 5 agents assigned to our Office of Professional Responsibility here in Washington, D.C., and those agents work exclusively in misconduct investigations on GS-15s, SCS, and presidential appointees or political appointees. In the field, I have another 34 agents that work not only misconduct investigations, they also work most of the grant and contract fraud. The fraud cases are the bread and butter of the IG. Most of our criminal investigative work goes into trying to recoup the government's money, people that have stolen the money, the grant money, the contract money that EPA has put out. So to answer your question, ma'am, I have 5 full-time agents working nothing but misconduct in headquarters, and approximately 34 other agents working a combination of fraud cases, theft cases, threat cases, and misconduct cases in the field.
God, when I hear staffing levels like this, it reminds me about what we're all seeing on television with TSA. I can't believe that this is all because everybody's decided to get on a plane. I think at some point Congress has to understand that if you want people to do the job, there have to be a certain number of people to do it. Now, TSA is one thing, and they've been under great criticism because they've not always been able to keep, according to the GAO, weapons from getting through. So that's an interesting case. This, of course, is another level of complexity, and I'm going to have to ask you candidly, how can these investigators keep from cutting corners with these kinds of staffing levels you've described that apparently have changed during your time at the agency?
Well, ma'am, I've seen no evidence of any of my agents cutting corners, but what I have testified to previously earlier in the hearing is that I'm concerned that cases take way too much time to come to conclusion because, frankly, it's like the analogy of planes that are circling, and when do the planes land? The planes land when, using that analogy, when the investigation's complete.
But investigating employees' misconduct isn't the only responsibility of the IG.
That's correct, ma'am. We have the fraud cases and the threat cases, and we have quite a few threat investigations that we have right now. So we are constantly juggling, and obviously we prioritize every day, almost like an emergency room, you triage. We investigate and handle the most important cases first, but you still have to take care of the other cases that are in the pipeline.
What about the non-employee misconduct related investigations that the IG conducts?
Yes, most of our cases are in fact not misconduct. About approximately 60%.
Non-employee.
Yeah, approximately 60% of our cases are a combination of the fraud cases, threat cases, assault cases, or theft. When I say theft, not theft by employees, by theft by outsiders. Someone getting into a federal facility and stealing computers or stealing other equipment.
Well, there's a limit. I think we're beginning to see what the limits are. I wish you luck with the appropriations process.
Thank you, ma'am.
I thank the gentlewoman. I now recognize the gentleman from Michigan, Mr. Wahlberg, for 5 minutes.
Thank you, Mr. Chairman, and thanks to the panel. Mr. Myberg, this isn't the first time this committee has looked into EPA for its questionable FOIA practices. That's an issue I'd like to address. EPA has been notorious for having extremely long delays in responding to FOIA requests. In fact, one of our witnesses, recent witnesses, in a previous hearing here, Mark Edwards, a waters expert, professor at Virginia Tech, testified that he awaited several years for his FOIA request to be completed. In fact, many of his requests were filled the day after he appeared before this committee on the Flint water issue. This case, as well as others, I believe very clearly and should diminish the public's confidence in EPA's ability to be open and transparent. And so could you tell us why it takes EPA so long for these FOIA requests to be filled?
Congressman, I'll just speak very generally to this on a couple of matters. One is that we take our FOIA responsibilities very seriously, and we have found in recent years there has been a substantial increase in the number of FOIA requests we've received. In responding to that, we've tried to put together a FOIA expert assistance team to assist us in searching through documents and making sure that we're fully responsive. When was that team initiated? That team was initiated within the last year or so.
Are we seeing improvements on that you could tell us about?
We're working very hard. I don't have any statistics for you today, but we'll be glad to get back to you with more information.
I appreciate that, because I know that you have to get a lot of requests, undoubtedly. When we're dealing with very emotional issues, substantive issues, waters of the U.S., Flint water crisis, where government failed at all levels and people have been hurt. There certainly is emotional issues dealing with the requests that go on. But there are reasons why EPA has been brought in front of us on several occasions dealing with FOIA, and I would hope that be addressed. Going on to purchase cards that was introduced in I believe, our chairman's opening comments, how can EPA keep better track of the purchase cards and the usage of those cards by your employees?
Congressman, we've made a number of changes in response to interest from the Inspector General's office and this committee and our own management concern about this, to put in place better systems for keeping track of activities that occur in purchase cards and flagging anything that would be suspect. So we feel like we've made considerable progress on this over the last couple of years.
Has there been an audit done relative to the employees to make sure that we're not missing things?
On the financial audit, we've had a clean audit opinion for the last several years, but we're always continuing to follow up and make sure that we have appropriate systems in place to detect any misconduct.
Well, then why is it that EPA employees who spend thousands of dollars of EPA taxpayer money on personal expenses can get away with not having to reimburse the agency?
Congressman, obviously we share your concern about that. The cases that are before us today are cases that were over, for the most part, as Director Sullivan specified, were over a couple of years ago. We feel like we have made progress going forward to identify those cases and address them.
Well, the particular individual that expended over $22,000 in international roaming charges while vacationing, and I think we make that clear, while vacationing abroad, will that employee be required to reimburse the agency?
Congressman, I'm glad you brought that particular case up, because we are going back and trying to make another effort to recover the costs from that.
What's the challenge?
The challenge is going to be to determine which calls, even an employee on vacation may have made work-related contact back to the agency even while they were on vacation. We need to make sure we can separate those out and make a credible claim.
Mr. Sullivan, could you add any information to that relative to that specific individual?
Yes, Mr. Wahlberg. The individual actually resigned before we presented our findings to the agency, and then as a follow-up, the agency preliminarily determined that it was too difficult to decide of that 22,000, how many may have been work-related. But recently, though, as Mr. Myberg said, the agency came back to us, I believe in April last month, and said they are taking a second look at it and trying to present a bill to that former employee.
Well, I hope a second look would be taken at it, and I applaud that efforts and want to see that completed. But in the end, if there's fraudulent or criminal involvement with this employee, I would hope that we could get after them. If not, we'd appreciate you telling us how we can assist you in making law in place where we can take employees who are ruining the credibility of other good government employees, attempting to do the job in the best way possible, and yet the cloud is put on them because of people who are willing to misuse their purposes and the cards and tools that they have. And so help us out with that. I yield back.
I thank the gentleman. I now recognize the gentleman from South Carolina, Mr. Mulvaney.
Thank the Chairman. Mr. Myberg, I want to go back and follow up on a couple of questions that were raised during your discussion with Mr. Palmer. He was talking specifically about a circumstance in Alabama where, to use his language, there was an allegedly overzealous EPA employee. We hear this all the time. It ranges from the terms overzealous to shakedown, depending on who you're talking to. And I guess the question that didn't get asked, because we sort of ran out of time, is this. Has anybody ever been fired for doing that?
Congressman, I can't cite a specific example of somebody, and I'm going to interpret your question, and I need to know if I'm hearing it correctly, that been fired for
overreaching, using their position to intimidate somebody, using their position. Enforcing the law is what we hire you folks to do, right? But occasionally, I guess it's possible that a bureaucrat, that a government employee might overreach. They might not like the person they're dealing with. They might not like what they're doing. They might not approve of the business that person is in. I used to be a real estate developer, and I can assure you that there's a lot of folks who like to hug trees who don't like what I used to do for a living. So the temptation might be there for an ordinary human being to sort of use that power that the government gives to them as an employee of the state to say, you know what, I'm gonna push a little harder here. I'm gonna stick it to this person. Do you remember a single circumstance of anybody at the EPA ever being fired for that in your 40 years there?
Congressman, first of all, I appreciate your observation about the job of law enforcement is oftentimes not a popular job or one designed to make everybody like you. I am not aware in my own experience of a case that's similar to what I'm hearing you say as someone who overused or abused their authority and was subsequently terminated solely for that reason. But I'll ask the staff to go back and look and see if there is such a thing.
Okay. Mr. Sullivan, if there were allegations of that, like in the example that Mr. Palmer mentioned, that someone had been overzealous and perhaps exceeded their authority, let's use that term, maybe that's a little bit more neutral, would that rise to the level of something the OIG would look at?
It could, and but this is the first I'm hearing, though, Mr. Palmer brought this issue up. It has not been, to my knowledge, referred to the Inspector General's office as an allegation of misconduct.
Gotcha. And again, I'm using his as an example. He knows much more about his example in Alabama than I ever will. But so my question is more general. Have you ever investigated allegations of overreaching authority on the part of an EPA employee?
Yes. Yes.
Do you recall anybody ever being terminated for that action?
Off the top of my head, I can't recall specifically how the cases were adjudicated, but for example, we had allegations of people using their position to get a favor, something that's not readily available to a average citizen.
Okay.
Those type of instances. We've also had instances where people may have used government property to their personal gain, misused the government vehicle, let's say, misused government funds.
Okay, and there's actually, there was a fairly high profile, at least it's high profile to us, because it's in our briefing materials, about the employee in, I guess, the San Francisco area who lent out a trailer or a piece of equipment to an environmentalist group or something like that. Are you gentlemen familiar with those facts and circumstances?
I am familiar with that case.
And again, that person wasn't fired.
Was not fired.
So maybe my question is this, in my last minute, give me a couple of examples. What does it take to get fired from the EPA? What do you have to do? Do I have to kill somebody, or is it a little short of that?
It can be a little short of that,
Okay.
yes. There are cases where we've done terminations. In my experience, I've done terminations, and the kinds of behaviors that are involved are pretty unpleasant and not the kind of things that you would certainly want to ever have an employee engage in. But when they engage in those kind of things on a case-by-case basis, considering employees' due process rights and making sure that as a deciding official you've got all the facts, you've proved the allegations proven, that you followed the regulations of the process, that you do in fact terminate employees.
Help me understand, Mr. Meyberg, and I recognize the fact that we're speaking in generalities, but if you had to sort of estimate between when you're dealing with allegations of impropriety, and they're serious allegations, and you determine them to be valid allegations, that actually some substance to them, what percentage of people quit or retire versus get fired under those circumstances?
Congressman, I don't have an exact percentage, but it is not uncommon that people who find themselves faced with a proposed termination will make an election to retire or resign.
And if they retire or resign, they get to keep their benefits, right?
We have no authority under law.
I'm not saying that you do, but the answer is yes. They don't, they do get to keep their benefits.
Except in some very limited cases that involve treason or espionage or aiding terrorist groups.
So let me close with this. As a manager, which is what you are, you manage people, right? I used to do it, you do it, you've done it for a long time with EPA. Would it actually make your job easier if we gave you that additional tool to, on a case-by-case basis, or perhaps expand the existing case-by-case basis, to deny people who have been found to have acted improperly, to deny them some or all of their benefits even if they choose retirement or resignation over termination?
Congressman, I think I would answer that simply by saying that I think we have the abilities under our existing administrative tools to appropriately address conduct and misconduct and to hold employees accountable. And I'd want to make sure we're using those tools as effectively as we can.
But if we gave you this additional tool, it would help you, wouldn't it? Could?
That would be speculation, Congressman. I really couldn't say.
We do it all the time. But thank you very much, Mr. Myberg. I appreciate it.
I thank the gentleman. I now recognize the gentlewoman from the Virgin Islands, Ms. Pascat, for 5 minutes.
Thank you, Mr. Chairman. Good morning.
Good morning.
During last April's hearing at the EPA management issues, Chairman Chaffetz highlighted what he called, and I quote, management failures at the EPA. I'm not sure if that characterization is an appropriate one, and it appears that we're still in discussion about this today. But I wanted to discuss what has occurred since last April. And it's my understanding that the EPA has taken significant steps to address weaknesses in the disciplinary process. I don't think that necessarily firing a bunch of people means that you're a good manager. That may be the sign of a poor manager that constantly has to fire people rather than bring them up to speed and make them an appropriate worker. But Mr. Myberg, your testimony described the progress EPA has made, and you state, and I'm quoting here, as a result of the work of this committee, and especially Ranking Member Cummings, we have improved our working relationship with OIG, which has enabled us to take more efficient administrative actions. Would you care to elaborate on that, sir, on that statement?
Only to say, again, that this has been a two-way street, and we feel that we have reached out to the Inspector General's office. The Inspector General's office has reached out to us in pursuit of a common objective, which is we want to make sure that employees are held accountable and the misconduct cases are dealt with appropriately, while also making sure that we do that in a way that protects people.
So how is that different than your relationship previously?
I really couldn't say for the agency as a whole from before the time I got here, but I think there's been reach out on both sides, and it's really commendable.
Mr. Sullivan, would you agree with that? And your statement, I'm going to quote from you, that the agency's internal adjudication process has dramatically improved. Is that correct? And
yes, Ms. Plaskett. So I'll explain the difference prior to us having this biweekly meeting. For example, if we had a misconduct investigation in Denver or San Francisco, the folks at headquarters had very little visibility on that, and it may languish for months or years. Whereas now, every misconduct investigation that's pending across the agency, Mr. Myberg's staff, the attorneys at EPA headquarters, and the labor and employee relations folks, we meet biweekly, and that case heretofore that may have been languishing in San Francisco or Seattle or wherever is no longer allowed to languish. The folks at EPA headquarters have visibility on it, and they're pushing it along to make sure that those cases are addressed appropriately and expeditiously.
And you would say that the cases are moving at a much faster pace to closure than they were previously?
Absolutely, yes, ma'am. That's
and
correct.
you have evidence of that, quantitative evidence of that?
Yes. I could tell you that within the past year, we've successfully closed. Well, the agency has determined what disciplinary action to take, if any, and we've successfully closed our cases out at a much higher rate. So we can't close our case until we hear back from the agency as to what they're going to do.
Okay, and have you been satisfied with the recommendations that the agency has made on those cases?
Well, ma'am, that's something that our job is to collect the facts in a fair and unbiased manner. It's not relevant, my opinion, on whether I think discipline is appropriate or not. I defer completely to the agency in that regard.
Got you. And you said that the process that you're describing, Mr. Sullivan, and you quote, "I believe that this process can serve as a best practices model for the federal government." Is that correct?
Yes, ma'am. I've spoke to Mr. Cummings' staff and Mr. Chaffetz's staff, and they're taking an effort to reach out to the entire IG community using the EPA as a model to educate the rest of the IG community that maybe there's a way to get these cases moved faster government-wide.
I think that that would alleviate this committee maybe having to have as many hearings as they have to these other agencies, and we can get on with the actual work of Congress if we were to do that. But would you support efforts to encourage then government-wide adoption of this? And your office would be willing to work with this committee to do that?
We certainly do support that, and we have worked with the committee. But one just caveat, the EPA, we're unique, somewhat unique in that we don't have any subcomponents. There's just one EPA and there's one IG. If you take DHS or the Department of Justice, they have multiple subcomponents, and the model that we have in EPA probably wouldn't work in a department that has multiple subcomponents, just to put that out.
And have you thought about what would work in agencies like that?
No, ma'am, I really haven't given that much thought.
We got to get you thinking on this, Mr. Sullivan.
Thank you.
Okay. So it seems to me that EPA and IG have shown that better coordination and communication can help agencies take administrative action more quickly in misconduct cases. And I'm really grateful for the work that you've done since April from our first hearing to actually address many of these issues, move these cases along to closure. I don't believe, having managed many people, working at the Department of Justice, with the Deputy Attorney General's office managing 9,000 attorneys, that necessarily firing people is the measure by which one determines that you've done a good job in terms of dealing with misconduct. So I'm grateful for the work that you all have done, and yield the balance of my time.
I thank the gentlewoman. A couple housekeeping measures. Mr. Myberg, Mr. Micah would like to know that, for the record, and to have you answer back to committee, how many employees of the EPA get bonuses?
We'll supply that.
Percentage. We would appreciate it. I also want to make sure that we have dates certain, so the names and titles of the people that gave you the permission, I would expect those in 2 weeks. Can't be very many. I would expect them in 2 weeks. Okay, I'm a taskmaster. Okay. One last thing, Mr. Sullivan, are you aware of the Federal Vacancies Reform Act?
In general terms, sir, not in specificity.
Are you aware of anybody that had the same plausible conflict that's been made aware of today in this committee with Mr. Myberg?
No, I'm generally aware of the issue involving Mr. Myberg, but we were told by the agency that it's not an issue based on their counsel's opinion. But we have not investigated that issue, to my knowledge.
Did we also have the names from the people that you consulted at the EPA that gave you the talking points? That
Right. Our counsel's office, I know I was briefed that there was an issue, but I will get back to the committee on that through our counsel's office, and I'll let you know.
Yeah. I guess we have a gentleman right here, Mr. Duncan from Tennessee, is recognized for 5 minutes.
Well, that's all right, Mr. Chairman, since I just got here, so.
Okay. So with that, I would love those names within 2 weeks as well, the council that talked to you about that, and any other cases in regards to.
Well, I didn't speak directly to anyone from the EPA councils. I was just briefed in my office by my counsel's office. I believe we're at a meeting that this issue came up, and it's not, according to the agency's general counsel, it's not an issue. That's what I was told.
Yeah, I'd like to know from your counsel, the counsel from the EPA, that actually instructed that this wasn't a problem.
Yes, Mr.
I mean, you do see the conflict, because according to the Federal Vacancies Reform Act, anything that Mr. Myberg may be implementing may be of null and void based upon the premise that it's actually placed there. And so, you know, the culture that we're building here is predicated on the culture that exists at the top levels, and because you do lead by example. And that's what the problem is in this application, so, okay.
Yes, sir, I understand the task, and we'll get back to you.
Well, I will acknowledge Mr. Duncan for.
Well, Mr. Chairman, I'm sorry I was over on the floor and didn't get to hear some of this, but I am curious. I've read some of the material here about some of these employees who've been watching all this pornography for hours at a time, and then employees that have admitted stealing thousands of dollars from the EPA. Have all these employees, or have any of these employees been fired?
Mr. Congressman, again, there's a large number of the cases that we looked at here. Many of the employees are no longer with the agency. There were cases where people were proposed for termination and then resigned.
And they resigned?
Yes.
So you don't have any employees now at the EPA who have been found to have stolen money or have spent hours watching pornography and so forth? They've either left or resigned?
Congressman, there are employees who have been resigned or who have resigned or been terminated, and there are employees who have been disciplined in other means than resignation or termination. Some of them are still with the agency.
Discipline, in what ways do you discipline somebody like that?
Congressman, there's a wide range of disciplinary actions that are available to a deciding official based on a consideration of all the factors, such as how long the employee's been with the agency, the severity of the crime, or the severity of the misconduct, and they include all the way from, they can go all the way from reprimands to suspensions for a period of time to a reduction in grade.
And I'm assuming that you've changed some of these policies to make sure that this type of activity doesn't continue in the future.
Yes, we've changed a number of policies, and I think the staff came up and briefed the committee staff on policies and changes we've made specifically with respect to the viewing of pornography. So yes.
All right, thank you very much.
I thank the gentleman. If there's no further business, I thank the witnesses for their appearance here today. Without any further business, without objection, the committee stands adjourned.
Thank you, Paul.
You're welcome, Jimmy.